All right, so Zach Whitman with Elysium Law. I view you as a trust attorney, estate planning attorney, but what is that?
Yeah, so the estate planning attorney is kind of a broad term. So we do all things planning, so that's your estate planning, your creation of your will, your trust, and then also we litigate. So we do the enforcement and the litigation post death. So if somebody's passed away and there's a dispute over inheritances or the quality or validity of the trust document, we'll do that as well. So it's kind of a global term. Trust attorney encompasses both of those.
Okay. And what inspired you to get into estate planning and being a trust attorney?
Yeah, I kind of stumbled into it almost. I originally wanted to be a sports agent, and that's when I started out. I went to law school was to be a sports agent, and then while I was working for a professional basketball team in Reno, Nevada, I was able to host a veterans clinic, a pro bono clinic for veterans as part of our military appreciation game. And the focus of that was to create estate plans for veterans in the Reno Tahoe community, because the services they got from the VAs is pretty deficient. So I wasn't know what I expected with what we would get in turnout. And we ultimately partnered with the Attorney General's office of the state of Nevada, and we did 136 estate plans in one afternoon. And that really opened my eyes into how important and how many people need these services. And so once my wife and I got here to San Diego, we really kind of made it our goal to open a practice and to be in this type of law where we can help people. There's so much law that you're kind of breaking things apart or making a mess, and estate plan is one of the few areas where you can actually build something. And
Okay.
so that's one of the main reasons why we started this.
Okay. That's interesting to know. So when I think what a lot of people think about trusts or an estate, it sounds so regal and something that rich people have,
Yeah.
right? Like you hear trust fund babies and things like that, and you think, well, they have a trust, that they must be rich. So what actually is a trust and why is it important for just your average everyday run-of-the-mill homeowner with a wife or a husband or a partner? Maybe they have a kid or two. Why is it important for them to look into a trust or to have a trust?
Yeah, so I mean, at the core base level, a trust is a contract with yourself on how you're going to distribute your assets and what happens with your stuff when you pass away. That is a misconception that it's only for the wealthy or the ultra rich. There's kind of two main reasons we look to do estate planning. First is to avoid probate. Probate's the branch of the court system that helps administer people's estates and manage their affairs after they've passed away. I tell people that if you don't have an estate plan, the state of California has one for you. It's called intestate succession, and that maybe doesn't line up with how you want your assets to go after you've passed away. So if you have any interest in any form of control on who gets to inherit, you've spent a lot of time and effort building your wealth and your life, accumulating your properties, your businesses, and the like. You probably have an interest in where that goes and want to have a say in it. And so that's where the estate plan really comes in is you put in the guidebook of how you want your things to be handled after you passed away. And you most certainly don't want to end up in the probate court. And probate is bad for two main reasons. One, it takes a very long time. On average, 12 to 18 months is reasonable for how long it's going to take before your loved ones actually get to have the assets and start spending the money that they've inherited. And the second is it's incredibly expensive. So the attorney's fees are paid statutorily. So that means we get a percentage of the value of the estate. We don't care about equity or the mortgages or any of the debts. It's the fair market value. So if you have $1 million house with a $900,000 mortgage, we're looking at $1 million. The attorney's fees for that are going to be upwards of $24,000 just for routine administration. So probate's very expensive, takes a lot of time. And so that's one of the main reasons you do an estate plan for the ordinary people is to avoid probate. And the secondary is tax mitigation. While most people are not going to face a tax burden, it's the federal estate tax currently in 2024 is over $14 million a person. That number is going to change. It's going to change many times as Congress and the White House continue to turn over. And so we don't know where that threshold is going to be when you pass away. So we want to build in some base level tax mitigation in case that threshold goes much lower, or you have some form of a windfall, you win the lottery, or
Mhm.
life just kind of keeps going well. You want to have some base level planning in place. And so that's the other mechanism that just your kind of your standard revocable trusts give you.
Okay. So again, maybe if I'm understanding correctly, right? So I have a house, wife and a kid. If I don't have a trust, if now walk me through if I die or if my wife and I die, like what is the process of then either probate or trust? What happens?
Yeah, so we have to look at who's on title, right? If it's husband and wife, the first spouse dies, the other spouse gets the property.
Okay.
Uh, the situation we're really worried about is the car accident, the two of you going together, and then we ultimately need to know who's going to inherit. And if it is not in a trust, it's going to go through the probate court. If you have minor children, it's going to throw a whole nother wrinkle into it where those funds are earmarked for the kids through guardianship. So you're going to be stuck in the probate system. The only way to avoid it is a trust. And
Okay.
so, as long as an asset does not have a designated survivor on it, so your bank accounts, your retirement accounts, or your property, if they don't have that designated survivor, that has to go through probate.
Okay. Okay, so worst case scenario happens, my wife and I get in a car accident or plane and something happens to us both. We do not have a trust. No matter what, that property, assets, etc., are going to probate. And
Yes.
from what I'm understanding, you're going to get paid, and the other lawyers and all those things are going to get paid first, correct?
Yeah, so attorneys, we wrote the laws. We're going to make sure we get paid. We're very good at making sure we get paid. So the attorney's fees get paid off the top. Debts, so if there's any credit card debts or outstanding loans that need to get paid, those get paid first. And then what's left over is what gets divvied up to the heirs of the estate, and who the heirs ultimately are is usually a big question mark.
Right. So that's my question. If I have kids and we have a home, standard San Diego home that's called $1 million, if my wife and I happen to get into a car accident going to dinner and the unthinkable happens, that house goes into probate. It's going to take how many, 12 to 18 months to get through that process before we figure out that, first of all, you get paid. Second of all, our debts get paid. And then third of all, whatever's left over that little pittance goes to our children, which is not
Right.
what we initially probably wanted or expected or hoped to have at the end of the day.
Right. And if there are minor children involved, minor children can't inherit until they're 18. So
Mhm.
we're going to have court proceedings to supervise the spending of that money for that child's benefit for the duration of their childhood until they're 18. And that's more court involvement, more attorney's fees, more supervision, more restrictions. There's so many options we can do within a trust
Mhm.
to dictate how old your kids can be before they inherit. Most 18-year-olds probably shouldn't be handed $1 million. It's probably not going to be spent very well. Most parents likely don't want their kids to do that. And so in a trust, you can put in those parameters of how, when do they inherit, and you have a little bit more control from beyond the grave.
Yeah.
Um, but yeah, if it's going through the court system, you're at the mercy of the court system and the fees and time with it.
Right. So now what if I say, or what if I hear, well, we have a will. I think we have a will. It's something's written down somewhere. Now, what's the difference between a will and a trust in this scenario?
So the biggest misconception in my line of work is a will is good enough.
Mm.
A will does not avoid probate. A will has to be admitted to the court. The court has to approve it as a valid will. The only difference is that's your distribution plan will most likely be honored. If you say Jane and John get to inherit, but Jimmy doesn't, well, we'll be able to follow that, but you're still at the mercy of the court system. The court, just because you have a will doesn't mean that's a valid will or that your executor is your executor. An
Right.
executor is only appointed by a court. So your will still has to go through the court system.
Right.
A trust is the only mechanism to keep it out of the court.
Gotcha. Okay, so how does having a trust then essentially benefit the surviving members that are left. So again, the scenario where my wife and I unfortunately pass away, we have three little kids, we have family members. How does it benefit them?
So the funds can be invested. That's the main issue, right? If you don't want your children to inherit until they're 30, you have that written down. You want your $1 million to be much more than $1 million when they turn 30. If there's 10 years before that time, you don't want that fund sitting in a non-interest bearing savings account. You want that money to grow. You want it to be invested. You want it to be used. And that's the best benefit you can give them is access to the funds. They have to go through the gatekeeper, your trustee, but they're going to have discretion to spend the money for them. If they need to go to school, if they need a car, if they have medical bills, the trustee can pay for them.
Mhm.
We don't have to go get a court's permission to spend the money.
Right.
And that's a huge benefit right there.
Okay. So, from my understanding now, it sounds very time consuming, very expensive to not have a trust.
Yes.
What is the cost of actually putting a trust together?
So trusts are usually drafted on a flat fee. We take a one-time payment for the estate plan. The price of it will vary based on the complexity of somebody's estate. Blended families, a little bit messier, takes a little bit more time. So most of the time, a married estate plan is going to be between 4 and 5 thousand. A single person's 3 to 4-ish. They can go up if there's a lot of assets and a lot of complexity, but that's pretty standard. So 4 to 5 for a married couple for an estate
Yeah.
plan.
But compared to 25 minimum $1,000 in just lawyer fees, let alone 12 to 18 months of process, it seems like a bargain, right?
In my opinion, it is. Yeah.
For most people, I would assume as well.
Yeah.
So what is the process of creating a trust look like? If someone calls you, like what do they do? What do they need prepared to have when they first call you, or what are the first few steps?
That's probably the most difficult point is the client wants to make sure they have everything in order. You don't need to have anything in order. That's part of our job as the attorney is to walk you through the process. We need to help guide you into making these decisions. So the process for us is a four-part process. The consultation is your first step. The second step is your planning meeting, and that's probably the most important and time-consuming meeting for us is we're going to walk through every decision. We're going to help guide you into who do you pick as your trustee, who's going to inherit, when do they inherit, how do you want assets managed. That's the planning meeting, but you need to use your attorney. Let us help you. You don't need to have this all figured out. We're
Yeah,
going to give you homework. You're
right.
not going to have every answer.
Yeah,
And so that's the biggest meeting. That's your planning meeting. Next, we review the documents with you. That's the third phase is we review everything. We look at the documents, make sure you understand. It's your opportunity to change your mind. Go, oh, now I see how this works. That's not really what I meant. Let's change it. And
Mhm.
once we get the trust and the documents how you want it and you're comfortable with it, then we get together, we meet in person and we sign your documents. And at that point, you're done.
Yeah,
You have your trust in place. We have to make sure we get your assets into your trust. But at that point, you're ready to go. You have it in paper, and these documents are intended to grow with you. It's supposed to be a living document.
right.
We can't plan for every foreseeable situation. Life happens, people die, things change, relationships change. So we need a plan for today.
Right.
Your estate plan should reflect your wishes today. When you leave my office, your estate needs to look like how you want it to be administered if you get in a car accident on your way home from my office.
Mhm.
If things change, we can update it. Amending a trust is very simple.
Right. So that was my next question is, you know, when should you change it? How does it change? And how does someone prepare for those changes?
So we typically say look at your trust every 3 to 5 years,
Yeah.
but the main times to consider amendments are significant life events.
Mhm.
Marriages, births, deaths, those are big events to make sure. Let's look at your trust, make sure how that event will impact your decisions. Does it change your decisions? Is there somebody that has passed away that's in your documents that we need to remove? Those are really the main life events that we need to look at to when we change our documents.
Right.
The other big time, really more for us attorneys, is just the tax law change. If there's a big change in the tax laws, I'm going to be calling all of my clients and saying, hey, let's revisit this. I don't expect the clients to be paying attention to the federal government's
Yeah.
tax. That's our job. Let us do that. Don't worry about what the news is telling you about the death tax and how that's going to impact you. Let us worry about that and we'll call you if we need to.
Yeah.
But for you, it's making sure that when the life events happen, we take a moment to consider how that impacts your decisions.
Right. Fantastic. So if someone is interested in getting a trust, which I believe every homeowner, every person who has a home should, how do they get in contact with you? What should they do?
So we have our website that you can always go to, theelysiumlaw.com, or you can just give our office a call, 619-535-9212. You can send me an email, Zach@theelysiumlaw.com. However method of communication you prefer, you'll reach out and we'll help guide you through the process.
Fantastic. Well, I appreciate your time. I thank you so much for your insight. And is there any parting words you want to leave someone who's either about to buy a home or has just bought a home?
What I would say in imparting wisdom is the estate plan is your last gift to your family. Let's give you one last gift to them by putting things in order that's going to make it as easy as possible for your loved ones. When somebody dies, you should focus on mourning, not on the legal stuff. Let's make it as easy as possible so the family can focus on the mourning process and the things that matter.
Awesome. Well, I appreciate your time, Zach. Thank you so much. Thank you.
Thanks, Werner.